If somebody recently passed away that is close to you, you might be wondering who is allowed to file. Am I allowed to file probate? In this video, we're going to be going through exactly who is allowed to file for probate in the state of Missouri. Hi guys, my name is Dan Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri. We serve clients all across the state of Missouri when somebody passes away and helping them get through the probate process in court, okay? And the first thing to understand about who is allowed to file for probate is that it depends on the situation. It depends on the type of case. Now, you may have seen in some of my other videos the major different kinds of probate in the state of Missouri. We have full administration cases, we have small estate cases, we have determination of heirship cases, and we have refusal of letters cases. Okay, so it depends on which bucket you fall into, who is allowed to file. Let's start with the smallest and work our way up to the largest, okay? Let's talk about the smallest situation where we have a refusal of letters case, right? There's gonna be three different kinds of refusal of letters applications. One is spousal refusal of letters, so they can be filed by, you guessed it, the spouse. Nobody else is allowed to file a spousal refusal of letters application. They have to be married to the decedent at the time of death. And in most cases, they should not have been separated from the decedent for more than a year prior to the death. The second category are minor refusal of letters applications. These can obviously be filed by the minor children of the decedent. Now, most of the time, it's obviously not going to be a minor child that's filing these probate applications. It's going to be their parent or guardian, the surviving parent or guardian, if any, or other adult. Usually it's the adult guardian on behalf of the minor child. This can be filed whenever the decedent left minor children. Now, if there's both a spouse and a minor children, the court may need to make an allocation of the distribution between the spouse and the minor children, depending on the situation. The last category of refusal of letters is a creditor's refusal of letters. These can only be filed by a creditor of the estate. So this is somebody who believes that the estate owes them money, either because they paid most commonly because they paid the funeral bill or cremation or burial bill, or because they owe some other debt to the decedent, say like a loan obligation or some other debt of the deceased. Now, most of the time, the creditor refusal application is only going to be granted when it's the funeral bill creditor that paid that bill. This may vary some from county to county, but especially in St. Louis, a county in St. Louis City, that is generally what you'll see is that the court is going to want to see a funeral bill creditor in order to grant a creditor's refusal of letters. So those are the first three categories. A spousal refusal of letters can be filed by the spouse. Minor refusal of letters can be filed by a minor child or their adult guardian. And a creditor refusal of letters can be filed by a creditor of the estate. Now, these methods only work when the estate is under about $15,000 to $20,000. For spouses and minors, it's usually $20,000 to $24,000 in the net value of the estate. For creditors, it has to be less than $15,000. And it's also important to note that the creditor version can only be filed if it's less than $15,000 and there's no spouse, no minor children, and that the asset is not real estate. It only works for personal property. So, but who can file it has to be a creditor. All right, so that's the first major category of who can file these applications. So if you fall into any of those buckets, you might be able to file. The next layer up for slightly larger estates would be the small estate affidavit. Or if you're an heir that just doesn't qualify for one of the other buckets, like for example, if you're an adult child or an adult sibling of the deceased, in those situations, you're not going to fall into any of those buckets. People who can file a small estate affidavit, you have to be an heir of the deceased, right? So you have to be somebody who's entitled to the distribution of the property. So if you're a child of the deceased, you're going to need to be one of the recipients under their intestate estate. If there is a will, the will is going to govern who is able to file if it's timely filed. If we're within a year of death and that will has been timely filed, the named personal representative in the will is going to be the first person that has authority to file. But if there is no will or that doesn't name anybody as representative, then it's going to fall to the default heirs. So if, let's say, your brother passed away and he had two adult children, you don't know where they are, but you're trying to take care of your brother's estate, you're not allowed to file. They are living adult heirs. You are not an heir, even though you're trying to take care of your brother's estate and his kids are nowhere to be found. You're not an heir. You're not allowed to file for probate. They're the only ones who can file. All right. So that is how a small estate works. It either follows the will if it's within a year of death, or follows the intestate default distribution who may file for probate. The next additional type of probate is the determination of heirship case. This is another short form type of probate case that can be filed after a year of death when the value of the estate exceeds $40,000. Who can file for a determination of heirship? Anybody who is an heir or is claiming through an heir. At this point, the will is out of the picture. If we've waited this long to file, a will can no longer be filed in the state of Missouri, so the personal representative named in the will is no longer applicable. That doesn't matter anymore. The only thing that matters is who are the default heirs. If your brother died and has 2 children that are living, you are not an heir. You may not file a determination of heirship case. The court will throw you out. The only people that can file that petition are the heirs of the estate. Okay, or an heir claiming through an heir who has died afterward. So suppose that grandma died, she had 2 kids. One was your father and your aunt. Your aunt is still living, your father has passed away. Let's say your father passed away after your grandma. Normally his estate would have taken that share, but some courts will allow you to make the argument that you are an heir claiming through your father, and therefore we should be able to bypass his estate and you can claim directly. Now, this method is going to depend on the local judge in your county and whether or not they accept that kind of probate proceeding. In some cases, they're going to want to split that into 2. But the long and short of it is, in a determination of heirship case, you got to be an heir if you want to file a petition to determine the heirs. Okay? The last major category of probate cases are, in fact, probably the most common category of probate case, or the one you might be the most familiar with, and that's just a normal full probate administration to appoint a personal representative, sometimes referred to as an executor, to take over the administration of the estate. Now, as you may have learned from some of my other videos, this can only be done within 1 year of death and is generally only done when the value of the assets exceed $40,000. But who can file this petition? This is one where we've really got to follow the order of priority. It makes a big difference. If there is a will that has been admitted to probate or will be admitted to probate, the named representative in that will is the only person that will be granted the ability to file. If there is no will, or that the person named in the will is deceased or unwilling to act, then it falls to the surviving spouse, if any. They have primary authority to file for probate. They are the first priority person who can file for and be appointed as representative over the estate. If they refuse to cooperate or there is no spouse, the next order of priority would be the heirs or distributees, so the children or other collateral heirs of the estate after the spouse, okay? And if none of the above, then a spouse and an heir can also nominate someone. So if there is a surviving spouse, let's say your dad got remarried to your stepmom, your dad died, leaving your stepmom, she has control over whether or not she's going to get appointed representative in most cases, unless she can be disqualified, which is difficult to do. Generally, she's not going to be disqualified and she will be allowed to administer the estate. Now, if she doesn't want to, she can file a nomination. So you might say, well, she didn't want to do it, therefore it goes to me. Not so fast. It might go to you, but she could just as easily execute a nomination and name someone else, and that nomination would take precedence over you. So if she names her brother or her friend to do the administration of the estate, even though you're the eldest living child of your father, that nomination takes precedence over you as the heir child. So that's kind of the order of priority there. Whoever's named in the will, spouse, you, or spouse, nominee of the spouse, nominee of you, or anybody else who the court shall direct. And only if there's none of these people involved, generally will the court appoint the public administrator's office to administer the estate. Now, one more clarification I want to make. Anybody can file to be appointed representative, but you're probably not going to be appointed unless you follow into one of these categories. You're probably not going to have a successful application unless you follow the right order of precedence. Sometimes we see people run into the situation where they're like, stepmom isn't doing the job. She's not getting it started. I know there's property out there and I know she's entitled, but she's not doing it. In those kind of situations, you can file what's called a petition to require administration, where you're basically asking the judge, you're saying, hey judge, I know I'm not in priority right now, but somebody needs to administer this estate. please appoint someone. You can always throw your petition for letters into play, even if the spouse is alive, on the hope that he or she either doesn't participate, renounces, or is ordered to file and doesn't, in which case the court might decide to appoint you instead. But that is generally the order of priority. So you got to be careful in deciding whether it's going to be worth it and when is the bus going to be driven by somebody other than you. So those are some of the things to think about. Who is entitled to file for probate in the state of Missouri? I hope this video was helpful. If you want to learn more about Missouri probate, please go ahead and check out some of our other videos, and I will see you in the next one. Take care, guys.